Hey everybody, how's it going? Welcome back to Copper Jacket TV. So today we're going to be talking about one of the most important 2A cases in the state of California, which is Duncan v. Bonta. That's the case that challenges California's ban on magazines that can hold more than 10 rounds. Now, Duncan's been around for quite a while now. I mean, the better part of a decade. We've been talking about it on this channel since the day it was filed. As a matter of fact, Duncan is what gave us Freedom Week in California, where I believe I maxed out like 2 credit cards. It was a 1-week period where you could get whatever you want regardless of capacity, and it was pretty awesome. So again, Duncan's been around for a while. It's been passed around back and forth, currently sitting before the 9th Circuit Court of Appeals, and the 9th was waiting on Rahimi before they actually made a decision. Now, we've had some movement since then, and I got to tell you, it's, in my opinion, looking pretty good. So today I have a very important update for you in Duncan v. Bonta post Rahimi. So let's go ahead and talk about what's going on. This video is proud to be sponsored by American Hartford Gold. Listen, if there is one thing that those of us in the firearms community understand, it's that you cannot rely on the government for your protection. Not with your life, and especially not with your wealth. Look, throughout our lifetime, the dominance of the US dollar was unquestioned, but that may be changing. As we face unprecedented inflation, the world's biggest economies are ditching the dollar for the yen. Banks are failing left and right, and the government is discussing a total control of all of your money with the new digital dollar. Don't let your life savings become a casualty of failing corporations or currency wars. Now is the time to call the only precious metal dealer that I trust, American Hartford Gold. They'll show you how to protect your savings and retirement accounts by diversifying your wealth portfolio with physical gold and silver. With the finest products, amazing customer service, and a buyback commitment. American Hartford Gold has a 5-star rating from thousands of reviews and an A+ from the Better Business Bureau. American Hartford Gold supports content like this that is committed to bringing you the truth. Tell them I sent you and they'll give you up to $5,000 of free silver on your first order, so call them now. Click the link in the description or call 866-856-2507. That's 866-856-2507 or text COPPER to 65532. Again, that's 866-856-2507 or text COPPER to 65532.
I'm still not sure you've answered Judge Gruber's question. At least you have. I'm still confused. Second Amendment does not protect non-arms, does it?
Well, I think it does not protect non-arms unless
Well, does it protect this?
Okay, so let's go ahead and talk about what's going on here. So if you guys are like me and you like to keep up on your rights and know what the courts and the government are doing, and I assume that you do because you're watching this video, you know that Rahimi was both good and bad. It was bad because it seemed to have a lot of language that would support things like red flags, but it was good in the fact that there was also a lot of language that upheld the Bruin standard, and there was one specific line that I really liked in that, which said that all bearable arms, not just some of them, all bearable arms are presumptively protected by the Second Amendment. That is extremely important, especially when it comes to Duncan, because if you guys remember, during oral arguments in Duncan before the 9th Circuit, several of the judges actually kind of made statements that would lean towards the magazine just being an accessory and therefore not implicating the Second Amendment, and so you don't even need to go past the textual analysis of the Second Amendment and into history and tradition because, again, it's just an accessory and so it can be regulated by the government. That's kind of where their comments were leading them to.
I think what this circuit has said in Teixeira and other cases is it protects arms and it protects certain other things if they are necessary to the realization of the core right to
fair
self-defense.
enough. So I guess I'm stuck on what Judge Graber was asking you. If we were to determine that a large caliber magazine by itself is not an arm, it's not used to attack anybody else, and it's not necessary for the operation of a semi-automatic weapon, do we have to go further than that?
But we know that these are necessary for the overall function of arms, and therefore they are considered arms and protected by the Second Amendment. So it does really wipe away that particular aspect of the argument, which is what I think the 9th was leaning on here. Now, like I said before, there was a development just days ago. This is a brief that was filed by the plaintiffs that is absolutely masterful in response to the appellant's brief, so the state of California's brief on Rahimi to the 9th Circuit. This briefed the 9th Circuit in a way that is absolutely incredible. I mean, we're talking about simply one page One page that leads me to believe that we actually might win Duncan at the Ninth Circuit, which is actually kind of difficult to say, to be honest with you. But this was written so well that it actually gives me some hope. Let me show it to you. So let's go ahead and check this out. And I love this. It's just short and to the point. It says, "Dear Ms. Dwyer, the AG misreads the United States v. Rahimi, which confirms that California Penal Code 32310 is unconstitutional." Obviously, that's going to be the mag ban. First, Rahimi makes clear that the government always bears the burden to justify its regulation when its regulation regulates arms-bearing conduct. Rahimi also confirms that the Second Amendment extends prima facie to all instruments that constitute bearable arms. Again, there is that quote that I think is so important. It's going to help us in some cases here. Even those not yet in existence at the founding. Another very important part because, they like to lean on that, right? They couldn't have foreseen this stuff. There's no way they could have seen this type of innovation. But it says, and the Supreme Court has reiterated, that it didn't have to be in existence at the time of the founding to be protected. That defeats the AG's contention that this court should uphold 32310 without even engaging with our nation's historical tradition of firearms regulation. So they pretty much put that argument to bed in the very first paragraph with just a few sentences. Now it continues on to say, the AG's summary of Rahimi's historical tradition analysis also misses the critical point. To be sure, Rahimi explains that the appropriate analysis involves considering whether the challenge regulation is consistent with the principles that underpin our regulatory tradition. But the law in Rahimi was permissible because there is a regulatory tradition of restricting possession and use by those found by a court to be a present threat to others. Section 32310, by contrast, prohibits law-abiding citizens who have never been found to pose any threat to anyone from keeping and bearing feeding devices that not only enable the questionable self-defense weapons to function as so intended, but are unambiguous in modern America. And when it comes to laws that prohibit law-abiding citizens from keeping or bearing a class of arms outright, the Supreme Court has been explicit about both what our nation's regulatory tradition is and what principle underpins that tradition. The relevant historical tradition is of prohibiting the carrying of dangerous and unusual weapons. And the principle that underpins it is that the Second Amendment protects the possession and use of weapons that are in common use at that time. And again, it's citing NYSRPA v. Bruin. So it says, because nothing in Rahimi purports to disturb that principle, California's ban on feeding devices that are unquestionably in common use today remains flatly inconsistent with our nation's regulatory tradition and the principles underpinning it. So that's it, just one page, not 10 pages, because they didn't need 10 pages. As a matter of fact, they destroyed one of the Ninth Circuit's arguments in the first few sentences of the first paragraph, and that's whether or not the text of the Second Amendment is even implicated here, and whether they even need to go into the text and history analysis portion of it. Again, that was all done within the first paragraph. Now, in the second paragraph, not only do they say that Rahimi actually helps us because all of the quotes and the statements and the fact that it upholds the Bruin standard and so forth, but we're also dealing with two different cases here. We're dealing, one, with somebody who violated the law, and we're talking about prohibited people and their rights and stuff like that. This has to do with the law-abiding. Duncan infringes on law-abiding citizens' rights. People who have never done anything wrong are having their rights infringed on, and so you're talking about two different worlds altogether. But even if we look at those worlds as two separate things, law-abiding and not law-abiding, there's still language in Rahimi that absolutely helps us here. And if you ask me, just doing this in one page is an absolute slam dunk, and I think is going to make all the difference here. So now that we have the Supreme Court's decision that the Ninth Circuit was waiting on, now that we have the briefs from both the appellants and the appellees, this is where the Ninth Circuit is going to start moving forward now, and where we'll finally get a decision. Now, there could be several different ways this could go. I mean, it's back in the Ninth Circuit's hands. You know that they love to play games. We'll see what they do with Duncan at this point, but try and remember that this is a case that's already been remanded. It's already been at the district level twice. It's been heard en banc. It's been heard by a 3-judge panel. I mean, this case has been going back and forth, so their options are a little bit more limited than they used to be, at least the first time around. But I think that this right here is such a solid document that it's just, there's no other wording in it, right? They didn't make it so long and drawn out that it's kind of hard to follow. It's very simple, it's very concise, clear, to the point. And I think that they're going to have to look at this brief, right? And they're going to have to make their decision based off it. Because again, California's is much longer. They really had to stretch and reach a little bit. And so I think this helps us out greatly. But that also means that we're going to find out probably soon what's going to happen in Duncan. And remember that Duncan is holding up Miller. And Miller is another extremely important case, but that case isn't going to do anything. It's basically stuck in limbo until we get something here about Duncan. So we need movement in Duncan to get these other cases through the line, basically. So I wanted to let you guys know about that. An extremely important brief that could make all the difference in this case. And I'm very excited to see what happens, even though it's the 9th, right? You can't get too excited. You just kind of, either way, it's the 9th. You guys get it, right? Anyway, I want to thank you all very much for watching. I really do appreciate it. Please like, subscribe. You guys have a great day.